Hi and welcome. I see we have people starting to join us, and we're going to give things a little bit of a time here to make sure everybody gets on before we get started. Welcome everyone, and thank you for signing up for the webinar today. A couple of housekeeping things before we get started. I'm Lisa from the library, and with me is Stephen Matcha. He's our speaker today. This is a community class. We're not going to be issuing CLE certificates, so I just kind of wanted to get out in front of that in case I get any questions about that. Really, this class today was meant just for educational purposes and for the community. It will be an interactive session, so if any of you attending have questions, please feel free to put those in the Q&A place here. You'll see an icon on your screen that says Q&A with 2 speech bubbles. That's where we would like for any questions to be typed. And one of the nice things about that feature in Zoom is that you can submit the questions either under your name or anonymously, whatever you're comfortable with. We will be trying to get to those as much as possible at the end of the program today. One thing we would ask you is that keep the questions general. We are not here today to give individualized legal advice. This is, again, a general session for educational purposes. So we ask that you keep the questions general to the extent that you can. And then finally, one more thing, you will see a link to a survey at the end of the program today. And we'd appreciate if you took a minute or two to take our survey and give us feedback. So I think with that, I will go ahead and introduce Steve. We have Steve with us today. So grateful to have you here with your employment law expertise for our patrons. And Steve's been practicing for about 15 years now in the area of employment law. And I found it interesting that his interest in employment law was sparked by some family history. Maybe he'll want to tell you a little bit more about that. I don't know. Did you want to talk about that or have me tell him, Steve?
Fine. Either way, go right ahead.
Steve's grandmother, who worked in government job in Arizona, went to retire and found out that she was being offered different retirement benefits than the male retirees. And so she fought for the right to have equal retirement benefits from her government employer and won that case, taking it all the way to the U.S. Supreme Court. So I thought that was super interesting and kind of a fun fact about Steve and how he got interested in employment law. So Steve, with that, I'm going to turn it over to you.
Oh, I appreciate that. Thank you. Thank you, everyone, for being in attendance. Thank you to the San Diego Law Library for hosting. So what you can expect, basically, we're going to start with some of your options after a job loss. That can be a stressful time, and I'm really hoping to provide you some value to help weather that storm. After that, we'll have a broad overview of basic employment law, and that's going to take up the bulk of the presentation. Finally, well, not exactly finally, almost finally, we'll have the handling workplace issues on the job. That can also be a difficult time for people, and so I hope to provide you some value there, and then we'll conclude the presentation with some questions and answers. So first, had to do it. What would a lawyerly presentation be without a disclaimer? Law can be complex and it changes. That's why you shouldn't make any decisions based on this presentation. Instead, you should privately consult a lawyer familiar with the current law that could apply to your situation. So yeah, I'm gonna try to provide you as much as I can in terms of a broad overview, but yeah, the law does change. The terrain changes and its application to your particular situation may vary from some of the information that you see in today's presentation. So first, you're out of work and you need help now. What are your options? Well, the first thing, it can help to go back to the basics. You may think, well, this kind of goes without saying, but it's a challenging time losing, spending the majority of your waking hours in a workplace, going from that to not at all. So it's an important time to lean on family and friends, not only for emotional support, but also it could lead to other opportunities. So for example, if you speak with a family or friend, you're telling them what's going on and that you're back in the market, that may spark some ideas and some opportunities for you to advance into your next career move. They may realize, oh, I was just speaking with so-and-so last week, and they may have an opportunity they may need someone with your skill set. So, it could lead to something good. And if nothing else, it can kind of help you get some emotional balance and clarity to hop back in the saddle. Also, you're obviously going to want to be receiving some income. And one of the primary ways to do that is through the California Employment Development Department, otherwise known as the EDD. Now, the requirements for getting unemployment insurance benefits: first, there's got to be full or partial job loss. So what do we mean by a partial job loss? That means losing hours, going from a full to a part-time schedule. That could also be included. Also, there's got to be no misconduct on the part of the employee. So no fighting or stealing or anything like that. That's going to make it very difficult, if not impossible, to receive unemployment insurance benefits. Also, the employee has to be ready, willing, and able to work. And so to the extent that an employee is disabled from working and they need some time to recover before rejoining the workforce, then as an alternative to unemployment insurance benefits, they can apply for disability benefits also through the EDD. Also, it's important to look for new work. Again, it kind of seems like it goes without saying, but not only is it required to continue receiving unemployment insurance benefits, but just it's helpful to reduce worry and make that your new job. Since you're no longer at the former workplace, it can be very helpful to stay productively active and positive toward your next opportunity. Some additional resources include calling 211 if you need some additional help with life expenses or other resources. Also, there's this onwardca.org, and I've got a screenshot in this next slide. Here you've got you can just click this main button. It'll kind of take you through the process, or you can jump straight to whatever your needs may be. If you need help with life essentials like money, food, shelter, training to re-enter the workforce, or to branch off into a different direction, and also for searching for future jobs. Okay, so if you were fired and you want to know whether there's a claim, well, the first stop is the Atwill presumption. And some of you may have heard about this, and it's often been overgeneralized as an employee can leave for whatever reason, and an employer can fire the employee for whatever reason. But again, that's an overgeneralization. An exception to that would be, for example, if the employee has a contract for employment. Generally, I'd say the vast majority of employment relationships are at will, not contractual. There's not a separate written contract. But if there is, then the employee is going to have to consider whether to breach or break the promises under that contract and leave, or leave in accordance with that contract. And then on the employer side of things, yes, the employers do have some liberty in choosing who works for them and who continues to work for them, but they can't make that decision on an illegal basis. So the first stop, I'd say, in determining whether there could be a claim is whether there's an adverse action. Generally speaking, the first stop here is we're looking for some loss in pay, like a demotion, a suspension without pay, or a job loss. However, there doesn't necessarily need to be a loss in pay for there to be an actionable claim. As for example, with harassment. With harassment, the conduct either needs to be severe or pervasive. Severe conduct once can be enough, an offensive touching, for example, or conduct that's physically threatening or humiliating. Contrast that with pervasive conduct. It's frequent, over time, hostile, intimidating, offensive, or oppressive. Here, it's a critical question. So why is the supervisor, the coworkers, anyone, any agent of the employer, why are they taking these adverse actions against the employee? A central question, really central to a lot of the work that employment lawyers do. And you know, I apologize, I'm teasing you with it a little bit right now. We're going to put that, we're going to table that for now, but I promise we'll get back into that in more depth later on in the presentation. Also, an element of a claim is harm. There's got to be some harm. Again, we're putting this up on the shelf, but we'll bring it back down. And even if none of that, none of what we've discussed so far would seem to apply to your situation, there's still the possibility of wage claims. And again, we're going to get into that in more depth later on in the presentation. So your boss or coworkers were abusive. Isn't that illegal? Well, I think that's often an assumption that I get for people who come to speak with me. And here's where we get into more depth as to why the employer agent, their employee, a coworker, a supervisor, why they've taken the adverse action against the employee. And this is a critical question. So I tell people there's two types of jerks, and I'm trying to, you know, explain the type of motives that are illegal versus those that are not. First, you've got your general jerks, so to speak. People who are nasty to everyone indiscriminately. You know, I think we've all been in that unfortunate situation to be around those people who are just blanketly grumpy for whatever reason. But in that case, there's some case law circulating around that the law is not necessarily, it's not a civility code, so it's not necessarily to make employment and necessarily an enjoyable place to work. But that's not to say that being mean to people is without consequence. So for example, if there's some, if an employee is encountering a toxic element in their workplace and it's causing them emotional distress or an emotional injury as a result of that toxic person, then there is the possibility of a workers' compensation claim stemming from that emotional injury. But for purposes of our discussion, finding what's a legally actionable motive, an illegal motive for mistreating an employee, we're looking for those who target. And there's specific reasons, if they're targeting for any of these reasons that we're about to discuss, that makes it an illegal motive. So protected characteristics, for example, it's not okay for a supervisor or coworker to discriminate against a fellow employee based on race, age, gender, or disability, to name a few of the protected characteristics. And this pool of protected characteristics is expanding. So for example, we've got this proposed Senate Bill 238, and this would, if enacted, bring in an additional protected characteristic, the political affiliation or belief. And as I'm sure a lot of you have witnessed in the last several years, there's been a lot of political tension and hostility among people on that basis. And so I think the impetus of this law in enacting this one would be to remove that from the workplace, so that people can focus on the reason they're there, which is to do the job. Also, there's protected activities. So even if a person doesn't have a protected characteristic, or at least the motivation for taking the adverse action against them is not their protected characteristic, their involvement in certain activities is protected. So for example, complaining about something illegal or refusing to do something illegal. If an employer says, oh, don't worry about that, let's just do this the easy way or whatever, you know, I'm going to turn a blind eye to that. An employee is well within their rights to not have to do anything illegal to earn a living. Also, employees are should be free from retaliation for exercising a right. For example, taking a medical or family leave, or receiving a disability accommodation, among other protected activities. So how do we prove the illegal motive? This, for me personally, you know, being a law nerd, this is an interesting topic, and there's basically two ways to evidence motive. One is directly, another is circumstantially. Now, direct evidence, examples of that could include a supervisor outright telling an employee, I'm firing you because you're too old, or we need to bring in younger, cheaper workers. You know, I imagine some of the viewers out there, you might be chuckling, well, who would be ridiculous enough to outright say that? And yes, I think by and large, a lot of employers, a lot of people are savvy enough not to provide direct evidence of discrimination, but you'd be surprised, it still happens. Next is proving discrimination circumstantially. And there's a three-part test to this. First, the employee who bears the ultimate burden of proof, they're bringing the claim, they need to prove it to a fact finder, usually a panel of jurors, or sometimes a judge in a bench trial situation. But they have to establish an inference of illegal motive. And we'll talk more about that in a moment. And once the employee does that, then the burden shifts over to the employer to provide a legitimate reason. No, it's not what the employee is saying. This is the real reason why we took the adverse action. And then once the employer establishes that legitimate reason, the burden shifts back to the employee, who has the ultimate burden of proof, to show that the allegedly legitimate reason from the employer, it's a pretext, it's a false cover-up for what's really going on, that initial inference. So the inference, here let's take, for example, a failure to hire case. You've got a protected person for any of those reasons that we've already discussed. Either they've got a protected characteristic, or they've been involved in some protected activity, for example. They're qualified for the job, they don't get the job, and then there's some other circumstances to suggest an illegal motive, such as the position remaining open and the employer continuing to look for someone to fill it. Under those circumstances, I think many people would be suspicious that protected characteristic or protected activity is motivating the failure to hire that person. It doesn't necessarily outright prove it alone, but it at least raises that suspicion, and that's the point. It's been considered a minimal burden, but it still exists. It's got to at least raise that suspicion or inference. Next, we're looking at the legitimate reason. I've got this in quotes. So the employer has to come up with a legitimate reason for why they took the adverse action against the employee. And it doesn't have to be a good reason. That's why I've got that in the quotes. It just needs to be believable and unrelated to the protected reason. So for example, personal or professional jealousy can technically be considered legitimate. I know it's not legitimate like we would use in everyday speak. It's, while petty, if it's believed to be true, then that can be enough to satisfy that prong. And a more common reason, the most common reason that employers use for taking adverse action against employees is poor performance. So once the employer establishes that legitimate reason, then again, the employee who's got the burden of proving their claim has to show that it was a pretext, a false cover-up for the real protected reason. And that's why the employer took the adverse action against the employee. So some common ways to show pretext: an employee's clearly meeting all performance standards. So if an employer is trying to say, well, we took that adverse action, we fired the employee because they were performing so poorly, and the employee can demonstrate, well, no, in my last performance review a month before I was terminated, I received the highest ranking. I did very well, and I met all performance standards. That would make that performance reason seem false. And then also disparate treatment. So what do we mean by disparate treatment? Basically, some people being treated better than others. So this sort of loops back to what we were talking about earlier with targeting jerks. So some people who treat other people better, or at least not bad, and then other people in a protected group or who engaged in some protected activity, they target them for mistreatment. That's one way to show disparate treatment. So next, a question that employees often have is, has my employer been paying me correctly? And here's where we get back into the wage claim. We'll take that off the table here. And generally speaking, the law is very protective of employees in this area of law. They're being properly paid. In one of these cases back from 1918, the court mentions delay of payment or loss of wages results in deprivation of the necessities of life, suffering inability to meet just obligations to others, and in many cases may make the wage earner a charge upon the public. So obviously courts don't like that. That's against the public interest. They want people to meet their just obligations to others, being able to pay rent and put some food on the table. That's obviously important, and so courts are protective, and the law is protective of employees' rights to proper pay. So some examples of wage violations include not being paid all wages, unlawful deductions from wages, so deductions beyond the normal payroll taxes, that sort of thing. Unreimbursed expenses, not being paid, if an employee has to use their personal cell phone or mileage in the car, they've got to be reimbursed for that if it's a necessary consequence of their work for the employer. Not receiving meal and rest breaks, not being paid on time, either in the particular pay period or at the end of the employment. There's various penalties for that. Misclassification. So I wedged this in here in this discussion about wages because it's an issue that often comes up here. And misclassification in this context, it can mean two different things. So it's a homonym, like bark, for example. You could be talking about the outer covering of a tree. You could be talking about the noise a dog makes. Similarly, we could be talking about misclassification, whether a person is an employee or not an employee or an independent contractor, or whether, even if we know the person, the worker is an employee, are they exempt? Are they exempt from certain employment benefits? So the first branch is the worker an employee or an independent contractor? Well, first, workers are presumed to be employees. So unless the employer can prove otherwise, that's the presumption. They're assumed to be an employee. And I put employer in air quotes because technically the verbiage that's used is the hiring entity. But if the worker is presumed to be an employee, then the hiring entity is also presumed to be an employer. So how do we prove an independent contractor? Well, for how does the employer prove that a worker is an independent contractor? For the longest time, we had this Borello test, and that's what we were working with. I've got the case cite in there. And with the Borello test, there's multiple factors that a court would consider. Some of those factors may weigh in favor of the worker being considered an employee, whereas some of those factors may weigh in favor of the worker being considered an independent contractor. And in my opinion, it wasn't the most clear test. And so then we're still using both, by the way, but then in some contexts, then the court brought in this ABC test under dynamics. And this, you may recall, for example, Proposition 22 with the gig worker drivers. That's what this is all about, this misclassification issue, at least this branch of it that we're talking about right now. So the ABC test, first, the worker is performing work free from the direction and control of the hiring entity. It's outside the hiring entity's usual course of business. And C, customarily, the worker is customarily engaged in a separate business. So let's take a look at some examples. First, and in both examples, we're looking at a plumber. An independent contractor situation. You're looking at a plumber doing a job for a law office. Well, the plumber does the plumbing and the lawyers practice law. Plumbing isn't a usual part of a law practice. Well, hopefully it's not if the office amenities are working properly. And finally, the plumber is coming either themselves or in association with another business as a part of a separate plumbing business. Then a situation where you've got an employee, sorry, just trying to grab my screen here. Anyway, okay, an employee. So let's say you've got a plumber who's hired by a plumbing company. Well, they're either if they're supervised by someone at the plumbing company or another plumber who's working for that plumbing company, that would tend toward an employment relationship. It's part of the usual course of the plumbing business. Plumbing is central to their business. And if the worker is exclusively working for the plumbing business, then that's a giveaway. Could be working, yeah, that they are an employee. And I want to emphasize here, I've got these ors in bold, again, to emphasize that point that it's the employer who's got the burden of proof. And so we've got to, any one of these could render the relationship. Now, the other branch of misclassification. So let's say we know the worker is an employee. Well, are they exempt? And sometimes sometimes employees can be misclassified as exempt versus non-exempt. And what do we mean by exempt? Exempt basically means that they may not be entitled to receive certain benefits of employment that other employees would be entitled to receive, as for example, with overtime, pay requirements. And there's a lot of different exemptions, but what we're going to focus on here is these big three, the white collar exemptions, the professional, executive, and administrative exemptions. So professional exemption, generally speaking, lawyers, doctors, they're not going to be getting paid overtime. Executives, the CEO of the company isn't going to be getting paid, is going to be entitled to overtime. The administrative exemption. This one can get a little more murky, but here we're looking at someone who has independent discretion and judgment to make significant decisions that affect the course of the company. So in all of these situations, we're kind of looking at people who are higher up in the company, or really, higher up in the company, or have a license or whatnot. So another frequently asked question is, how much is my case worth? And here we'll be talking about harm. We're going to bring this one off the shelf. For wage claims, for example, let's take a look at a 9-hour day, no overtime is being paid, and the employee is not receiving a meal break. I've got an asterisk next to this 9-hour day because typically overtime is over 8 hours in a day, over 40 hours in a week. However, there's one exception. For example, the domestic worker bill of rights, people who are personal attendants working in home, their overtime starts over 9 and over 45. But generally speaking, overtime starts over 8, over 8 in a day, over 40 in a week. And so for this 9th hour of pay, the employee would be entitled to 1.5 times their regular hourly rate for the 9th hour of work, and an hour of pay for the missed meal break. And that's just looking at one day. There's also snowballing penalties. For example, if the employee's not paid on time, obviously if they weren't paid these amounts when they were due, they weren't paid on time. If they're not paid all amounts owed upon the severance of the employment relationship, there's waiting time penalties on top of that, among others. So these can really add up. In the situation of a wrongful termination or discrimination, some of the elements of damages for determining damages, how much is the case worth? Includes these lost wages, emotional distress damages, perhaps even punitive damages. With lost wages, we may be thinking, well, if someone's lost their job, obviously they've got some lost wages there. Well, not necessarily so. Sometimes it can be a blessing in disguise. An employee can leave their former employment and their new job pays more. Well, great, good for them. In that case, generally speaking, there's probably not that element of lost wages. You can kind of split hairs here. Perhaps the former job provided benefits that aren't available for in the new job, but we're just kind of looking at this in broad brush strokes. Emotional distress damages for having to go through the aggravation of the mistreatment. That's included in many of these claims that we've been discussing as well. One exception to that comes to mind is the USERRA, the Uniform Services Employment and Reemployment Rights Act. It's gross oversimplification here, but it's basically military discrimination. You don't have emotional distress damages there. What they have instead is something called liquidated damages. So it's basically mirroring the lost wages. So you need to have that component of damages. And then punitive damages. So here we're looking for really bad conduct, malice, fraud, or oppression, either authorized or condoned by people in management, basically, of the company. And so if they've just really done something in reckless disregard of the employee's rights, these punitive damages are to make an example of the employer. Not always available, but for some egregious conduct, they can be. And then there's also attorney fees. So for much of the claims that we've been discussing thus far, if an employee has to get the services of an attorney to help them vindicate their rights, and they prevail, the employer could be on the hook for their attorney fees. So what are the deadlines for bringing a case? And I need to apologize up front. I'm going to be intentionally vague here because this is a very thorny and critical subject. But the main takeaway is that claims have deadlines. It's, they, generally speaking, they can be like milk. If, once they expire, you lose the benefit of, them. So it's important to clearly understand what those deadlines are. So for example, just looking at wage claims, those can vary from 1 to 4 years depending on the type of claim. So yeah, a critical topic that's important to clearly understand. Here too, there's also called something, it's called the exhaustion of administrative remedies. So if you ever come across that and think, what does that mean? It's basically sort of a fancy, perhaps convoluted way of saying hoops. It's like hoops that an employee has to jump through before they can go to court. So for example, with my discrimination or retaliation cases, before I can bring those to court, what I personally do is I'll go to, you've got to exhaust administrative remedies before bringing those for, violation of the Fair Employment and Housing Act, which is a lot of what we were talking about earlier. So then I'd go to the Department of Fair Employment and Housing and ask them for an immediate right to sue notice, which you just go through the computer system and they spit that right back out to you, and then you can go on to court. It's important to do those properly, obviously. And that's not the only option. Through the Department of Fair Employment and Housing, I understand that they've got an option to help investigate, mediate some of the claims. But like many government entities, and agencies, especially in light of COVID, there's some pretty serious backlogs. So that may take a while. Also, again, we're talking about deadlines. And so here's a side note for government employees. Government employment, it's really its own animal. And it'll become apparent in a moment why I wedged this in this segment about the deadlines. So before bringing several claims, there's a Government Claims Act requirement that has to be exhausted, a hoop that people have to go through before they can go to court. Then there's also these Skelly hearings, or with the Merit Systems Protection Board for federal employees. And those, that's basically like if an employee, if a person chooses to pursue a career in government, generally speaking, not always, but they're considered to have a property interest in their job that cannot be taken without due process of law. And so that's where these come in. And then for these MSPB and Skelly hearings. And then there's the Equal Employment Opportunity Commission. They've got a private sector Equal Employment Opportunity Commission and a work sharing agreement with the Department of Fair Employment and Housing for private sector employees, as opposed to people working for the federal government. But for federal employees, for many of their discrimination claims, they've got to go through this EEOC. So why do I bring all this up? Wedge this in this segment on deadlines, because with government employees, the deadlines can be very short. We're talking months, weeks, sometimes, a lot of these are measured in days. So it's really important that if you're a government employee considering pursuing claims, that you really understand those deadlines. All right, so there's a claim. Is it worth pursuing? Well, there's a few considerations here. One, it's important to have realistic expectations. So I often tell people, Lady Justice, she's wearing a blindfold, she's got her scales, but she's not wearing running shoes. And I think that's especially true in light of all the COVID backlogs. A lot of things are backlogged, so it can take some time to resolve. However, if the employer and the employee mutually agree to resolve or settle their claims outside of court, that can expedite the process. And some factors that could encourage an employer to want to do that rather than have to go through the whole process include the strengths of the claims and the availability of attorney fees. So an employer may be thinking, well, geez, we've got some pretty strong claims here. And if the employee prevails, and it looks like they've got a good chance of that, they could get their attorney fees. It could cost us a lot more down the road. So perhaps it's a good idea to try and resolve the claims. Another consideration is the employer's ability to pay. And here I want to emphasize that it doesn't make any of the underlying conduct right. It's just a practical consideration. So let's say you've got someone who's a single person operated flower stand by the side of the road, and nothing disparaging about that. That's that's wonderful. But let's say they hire a person and they don't pay that person in accordance with California law. Well, that person may have a limited ability to pay for the resultant damages. Am I saying not to pursue those claims? No, I'm not saying that, but that's just something to consider. And when seeking out attorneys, that you may be wondering, well, I've got some really strong claims. Why aren't I getting interest? That might be one of those reasons. Sometimes what I'll, a saying that I use with some people is, is a juice worth the squeeze. It may be a lot of effort for no gain at the end of that, or very little. So thank you for sticking with me so far. We're almost at the end of the presentation, and here I'd like to give some pointers for people who are they're at work, they're struggling with some employment issues. What do they do with that? Here, first, let's assume that the employee wants to try to work it out with the employer. Well, the employers have various obligations, including to prevent and correct some of the misconduct, and to interact and reasonably accommodate employees with disabilities by, for example, if an employee needs changes to some of the non-essential functions of their job, and an employer can reasonably do that, then they have an obligation to do that, so the disabled employee can continue to work for them. Now, I've got two approaches here that an employee could take: the indignant approach and the more collaborative approach. So, for example, with the indignant approach, oh, you dirtbags, I can't believe this is happening here. This should have been fixed yesterday. And, contrast that with the more collaborative approach, which is, well, so-and-so said something inappropriate to me a few weeks ago. I let that person know. It made me uncomfortable. And lo and behold, they've done it again. And so I need that to stop so that I can, I really enjoy my work here, and so that I can focus on my work. And I can't focus on my work and do the best possible job if I've got that going on. Do you kind of see I suppose opinions could differ on that, but but do you see the contrast? One is alienated and really sort of makes it difficult to continue the employment relationship, whereas the other is more collaborative. Also, while working through some of these issues, it can be important to keep a timeline and document and save communications, including emails, texts, voice messages, that could be critical pieces of information later on. So if there's any dispute of fact, the employer is saying, the employee is saying, well, this happened, it happened this way. It was, this is what you told me, or this is what, this is what was promised. And the employer says, no. Well, this kind of information can help resolve those evidentiary disputes. So let's say you've moved on from from trying to preserve the employment relationship to deciding, well, it's time to leave. Okay, a few things. Obviously, it can be good to start looking for work while you still have a job. It can be easier to find and transition into a new opportunity. And also, it goes without saying, it can help to try and save. And if there's an unexpected termination, or and you need to supplement unemployment insurance benefits to maintain your lifestyle, that can be very, very helpful. speaking of unemployment insurance benefits, here's another word of caution. I don't want to encourage anyone to stay in a toxic work environment and bring that misery home to their families or anything like that. Just a few things to note though. For unemployment insurance benefits, generally I've found that it can be more difficult to receive those when an employee quits or resigns. However, it's not impossible if, for example, the work environment was intolerable. And if possible, the employee attempted to fix those intolerable conditions with the employer, then under those circumstances, they may be able to receive unemployment insurance benefits. And not only that, if the work environment is considered intolerable, it may also give the employee a claim for constructive termination. So what does that mean, constructive termination? Well, the employer hasn't exactly terminated the employee, they've constructively terminated the employee. They've made the work environment so intolerable that the employee had no choice but to leave. And that's the crux of that claim. Thank you very much for your time and attention today. And here we'll move on to questions and answers. I've got my phone number up here as well as email address. If I can't, I really do appreciate your attendance here today. And if I can't get to all of your questions, feel free to email me and I'd be happy to help you unpack your questions. So with that, I'll turn it back over to Lisa.
Yes, we do have several questions. I think these are all about misclassification so far. So let me read a few for you here. Can the status of an independent contractor be negated by an actual contract between the hiring entity and the person doing the work? For example, if the person doing the work is hired for a term or for certain jobs.
Yes, I've seen that where an employer will attempt to use a contract so that to say, well, look, we both agree that this person is an independent contractor and we've agreed to that by contract. But what I've found, and I'd like to reference go back and reference some case law on that. But generally speaking, it's like trying to override employment law with a private contract. That can't be done.
So I think this may be a follow-up to the first one. What if a person is called an independent contractor, even though he or she meets the ABC test, yet the employer says no because the worker has a part-time job doing the same thing for someone else?
Yeah, okay, so if in the case of a person who's, if I understand this correctly, a person who's misclassified as an independent contractor and the employer is adamant about that, no, you are not an employee, you are an independent contractor, and it turns out that they satisfy all of the elements of the ABC test. Really, they only need to satisfy one of those elements of the ABC test to be considered an employee. If the worker is an employee, although they've been misclassified as an independent contractor, then that could result in substantial damages being owed to the employee. For example, if they've every day of their work for the employer, they've worked a few hours of overtime and they didn't get paid any additional amounts for that, the employer is going to be on the hook for that. If they've since left the employment or the working relationship and they haven't been paid all of those overtime wages, the employer is going to be on the hook for even more in terms of waiting time penalties. So that could be a very expensive situation. And I think that was a lot of the that sort of interesting social development with Proposition 22 and all the commercials for the gig workers and whatnot. It's a very high stakes issue. So yeah, if a worker's been misclassified as an independent contractor when really they're an employee, that could result in some substantial amounts owed by the employer.
So another question we have is whether workers who are employed in California but working for a federal program are protected by California laws, such as the ABC test.
That's interesting. So would you mind reading that one back to me?
Sure. Are workers employed in California yet working for a federal program protected by California laws, such as the ABC test?
Okay, so yeah, you've got someone who's working geographically in California, but for a federal agency or a federally funded program. That's an interesting question, and I'd want to take a closer look at that. Yeah, and it's like I was saying earlier, government employees, it's kind of its own animal. So yeah, that one can get complex. But whoever asked that question, please do feel free to email me. I really appreciate your time and attention and asking that thoughtful question. So yeah, I'd like to help you however I can with that. So feel free to send me a follow-up email and we can work on that.
So next question, hello, great presentation. I agree. Thank you for the compliment to this person asking this question. One question, if an employee wins a wage claim before the labor commissioner, does the commissioner help enforce the judgment? Is it enforced by a lien? And thank you for answering that.
Yes, so the labor commissioner, they do have an enforcement unit. So what happens is the employee goes through the labor commissioner process. They win a decision, and then the labor commissioner they go to court on behalf of the employee and ask for that be solidified into a judgment. And then their judgment enforcement unit, I think that's what it's called, JEU, then proceeds to collect on that judgment. But I think as I mentioned before, one important thing to note is that, especially with COVID and all this other stuff, there's substantial backlog in government agencies, so it may take a while to collect that. And in that case, there is a potential alternative. If the employee, they go through the labor commissioner process, they get the judgment, they can either have the labor commissioner, they can either leave it with the judgment enforcement unit to try and collect on that whenever they can, or they can try to seek an attorney who would do private collections, and they can get the judgment. Basically, they can take the judgment and try to collect it on their own or in association with someone who does collections work. So those are some options.
Another question, this is about bonuses. This person is asking, I understand bonuses are taxed at a higher rate in California. I suppose they mean compared to other states here. However, a bonus in lieu of a pay raise, for a bonus in lieu of a pay raise, is the tax rate the same? Could that be a form of harassment if only done to one employee?
Well, I see at least two parts to that question. One being a tax question, which I'm just going to unabashedly say I have very, very limited knowledge in the area of tax law. So, I apologize. I won't be too much help there. But if it's substantial and you really like to unpack it, I would be happy to try to route you to someone who might be able to help you with that tax question. So again, feel free to email me. As for the second part of that question, whether if one person, is a part of a group of other employees, those other employees are just receive pay raises, where this other employee is targeted for just receiving a bonus, and there's some disadvantage to that employee, as for example, perhaps poor tax treatment, and they're having to spend more in taxes. That could be illegal discrimination, depending on, again, that critical question: why? Why was the employee targeted for being given that bonus, whereas the others weren't? If it had to do with a protected reason or a protected characteristic, then we further unpack the analysis, and there could be some illegal discrimination or retaliation there.
So we do have a few more minutes. If there's anyone else out there with a burning question, feel free to put it in Q&A. While we're waiting to see if there's any more questions, I actually had one for you, Steve. I've seen some postings online lately about people having difficulty collecting their unemployment benefits from EDD. I know this is where you started today. I wonder, do you have any tips or any wisdom for people about dealing with EDD, what to do if they are having some trouble? For instance, they've been awarded some benefits, but for some reason they're not receiving them. Is that something you can comment on?
That's a fantastic question, because people need that. It's in place as a social mechanism for people to continue on living, despite that break in employment. And frankly, I don't have a clear answer to that question. However, I do understand, I was speaking with an attorney some months ago about the EDD having certain requirements, and perhaps even certain timing requirements by which they need to process these claims. And so I believe he's bringing an action on behalf of those employees who yeah, I really sympathize with someone in that situation. They need that money to continue living. So that's a tough situation. And while I personally wouldn't be able to help, I may be able to make a connection to someone who could.
Another question we received, this is a good one. You mentioned the issue of harm. Is that subject matter limited to lost wages, emotional distress, or punitive damages, or could it include lost opportunities?
Oh, that's a good question. And so, for example, loss of a promotional opportunity because of you've got someone who has been put on a performance improvement plan or something. And so as a result, part of the terms of that are they're not able to make a transfer, or, they're not able to seize an opportunity that they would otherwise be able to seize. Yes, I would say that to the extent that that could be monetized, you could say, well, as a result of, I hope I've got the gist of this question, as a result of, for example, being put on a performance improvement plan, and now I can't apply for this other position in the company, whereby I would be receiving greater income or benefits or whatnot. That could be an aspect of those economic damages. Not to mention the emotional distress and frustration as a result of having that opportunity foreclosed. So I think there's a way to frame that so that it could be compensable, again, assuming that there's underlying liability, there's illegal discrimination, retaliation, etc.
Okay, and another question, I think this might be the last one with the time we have left. What are your thoughts on if one exempt employee repeatedly receives overtime pay, however, all other employees are required to stay under 40 hours or reduce their hours to 40 hours?
Oh, okay. So perhaps, it's kind of like the reverse of what we were talking about earlier in terms of disparate treatment, rather than, one person is receiving greater benefits, rather than is being targeted for greater benefits, whereas the other employees aren't. Again, I think it could be framed as illegal. For example, if it can be shown that the employees who weren't getting that same opportunity were in a protected group, or they engaged in some protected activity, and this other person was outside of that, there could be a claim there. You just need to kind of unpack it and do the analysis.
Yeah, I think that's one of the challenges with some of these subject matters are so fact driven, right? You know, you really need to have all the details to have a firm opinion. Well, thank you so much. Great presentation. We covered a lot of territory, I think, in an hour, and we're out of time. So thank you everyone for attending, and thank you, Stephen, for the presentation.